Hi, everybody. My name is Austin Segal, and I am the Director of Research and Jill DuPont Memorial Fellow at Chicago Appleseed, which is an advocacy organization using research to identify injustices in Cook County's legal system and interrupt mass incarceration. And this event is being put on by us as well as Mamas Activating Movements for Abolition and Solidarity, which is an abolitionist reproductive justice collective building power among mothers and caregivers of color in Chicago. Today, you'll get a presentation by me, as well as we'll have three speakers from Mamas, Akeisha Lee, April Ward, and Rosemary Cade, who are all members of Mamas speaking today from our Mothers of the Kidnapped Collective. They are mothering incarcerated children, and their sons are wrongfully convicted as a result of police torture and frame-ups. Today, we'll be starting with that presentation about Burke's policies, as I mentioned. Then we'll be going on to the speakers, and then there will be a chance after all of that for a Q&A. So feel free to put your questions in the chat as they come up, and later we will be answering those questions. So without further ado, I will begin presenting. Chicago Appleseed published a report a few months ago called 500 Days Forward, 10 Years Back, which covers Eileen O'Neill Burke's policies in her first 500 days in office. For this report, we pulled from multiple sources, including formal policy documents from the state's attorney's office, as well as press releases, news articles, a lot of quantitative data analysis, and some conversations with our community partners. Eileen O'Neill Burke first took office on December 2nd, 2024. So we have passed the 500-day mark, as this report shows, and we are coming on to 2 years now. And in the Burke administration's first 500 days, it radically reshaped the office's priorities, the office being the Cook County State's Attorney's Office. It reshaped the priorities around charging, detention, diversion, and sentencing, accountability of law enforcement, and court transparency. Eileen O'Neill Burke came into office following Kim Foxx, who, herself a controversial figure, but she was known by many as a more reform-oriented prosecutor than some others. And as this presentation will show, Eileen O'Neill Burke came in and pretty radically reshaped that. So first, we will talk about charging, detention, diversion, and sentencing. First of all, felony retail theft. So there is a statewide threshold for felony retail theft that basically makes it so that across the state, retail theft cases are generally charged as felonies if one of the following two things is true. Either the goods allegedly stolen add up to more than $300, or the person has a felony retail theft conviction in their background. Kim Foxx, very early in her administration, raised the felony threshold to $1,000 so that she would only charge retail theft as a felony if the goods allegedly stolen were worth more than $1,000. And she made it so that instead of a single felony retail theft conviction, somebody needed to have 10 retail theft convictions for the Cook County State's Attorney's Office to charge them with a felony for stealing allegedly less than $300 worth of things. So Eileen O'Neill Burke basically, what she did is put it back to the state threshold. So she undid what Kim Foxx did, so that, sorry, this is a lot of numbers, but the state's attorney's office is now once again charging retail theft as a felony, even if it's just $300 or more of goods stolen. So this means that the office is charging more retail theft cases as felonies. And we see in the data, as you can see on the right, that this had an immediate impact, because in 2025, 36% of retail theft cases were charged as felonies, as opposed to 18% the year prior. And felony convictions have incredibly harmful consequences for people for the rest of their lives. It can disrupt their housing, employment, education, etc., for years to come. So, especially because retail theft is largely a consequence of poverty in Chicago, charging people with felonies does not actually address the root causes of retail theft. Next, I want to talk about pretrial jailing. So, as many of you may know, the Pretrial Fairness Act, implemented in 2023, abolished money bond. So now decisions about whether someone will be jailed before their trial are never based on whether they can afford to post bail. It also famously requires that decisions about pretrial detention are individualized and really take into account all of the details of the case. In spite of this, the Burke administration has implemented a new policy, but by new, I mean they did it on their first day of the Burke administration. But this policy seeks detention in a very indiscriminate manner because it seeks detention for any cases where certain factors and charges are present. For gun possession, this means that gun possession cases are the state's attorney's office is seeking detention for these cases whenever the gun is allegedly untraceable, defaced, modified in any way, etc. This is really important because gun possession in Chicago is largely a consequence of people not feeling safe in their communities. We know now, I mean, we know in general that the way to address this is to invest in our communities, allow people to have the resources to keep their own communities safe. But instead, the Burke administration is using pretrial jailing and harmful carceral policies as a way to deal with what is ultimately a public health issue of gun violence. And as a reminder, these gun possession cases do not involve any violence or use of guns. They are simply carrying or possessing a gun in an unlawful way, which often means that they don't have the proper licensure to have a gun. So going back to pretrial jailing, Eileen O'Neill Burke's policy has also had huge impacts for jailing for gun possession, whereas Kim Foxx in her last year in office sought detention for about a quarter of gun possession cases. Eileen O'Neill Burke in her first year in office sought to detain a majority of people accused of gun possession. And this resulted in 30% of people with gun possession cases being detained, which pretrial jailing poses a lot of the same harms as other forms of incarceration and can also be incredibly disruptive to people's lives. We have also seen increased pretrial jailing for domestic violence. And what's really important to remember when it comes to domestic violence cases is that part of best practices for domestic violence cases is that survivors should have as most autonomy as possible over their case at every step in the process. They should have control over every part of the case, and that includes pretrial jailing, because only a survivor knows what is best for them in their situation. So as before, the state's attorney's office is seeking detention indiscriminately for domestic battery cases. Essentially, the state's attorney's office is seeking detention in every domestic battery case if it is either charged as a felony or if the case allegedly involved a firearm. Of course, there are often incredibly large safety risks when it comes to domestic violence, and it is incredibly important to keep survivors safe. But that is why it is especially important to value the input of survivors when you are making decisions about whether to seek detention in a case. And this policy, because it requires it basically means that the office will always seek detention when these factors are present. It doesn't actually leave any room for survivors to have a say in whether they seek detention in their case. All of these policies have resulted in an increase in the Cook County jail population. We've seen the jail population decrease various times over the years because of policy. For example, General Order number 18.8A when that was implemented, there was a large decrease in the jail population. I won't go into it, but that general order made it so that judges were not supposed to charge or were not supposed to impose bond amounts that accused people couldn't pay. But going on to the present day, we saw the Pretrial Fairness Act. After that was implemented, there was a pretty sharp decrease in the jail population. But we have seen the jail population climbing back up in the years since then. And it is now around 6,000 people in Cook County Jail at any given time, which is around what it was before the Pretrial Fairness Act was implemented. And this is largely a direct result of Eileen O'Neill Burke's harmful detention policies. And our speakers later will be able to speak more about the harms of these policies when it comes to pretrial detention. Next, I want to discuss Burke's policies regarding diversion for gun possession. So if you don't know, diversion programs are basically an off-ramp for people who are charged with a crime. They can be pre-plea, which means that they avoid the traditional legal process. And if they successfully complete the program, their case will be dismissed. And then there are post-plea programs where if somebody has to plead guilty in order to join the program, and if they are unsuccessful in the program, then they could be they could have a sentence, they could have a conviction on their record for the charge. So there is a program called the Restorative Justice Community Courts that has mostly taken gun possession cases in recent years. And Eileen O'Neill Burke stopped diverting gun possession cases to that program in the beginning of 2025 and later reversed that policy earlier this year after getting a lot of community backlash. Burke has also advocated for legislation that allows some people to apply for a FOID card while they are still in a diversion program for gun possession, which is a good change. It will allow people to avoid the waiting period after their diversion program ends, because we do know that for a lot of people, the only thing preventing them from legally owning a gun is having a license. So she advocated for that legislation. And as a result of that legislation, we do now have an additional diversion program for gun possession called the Gun Accountability Program. It's pretty similar to another program we have called the First Time Weapon Offense Program, except two big things. This one is a pre-plea program. As I said before, those are better because somebody does not have to plead guilty to join it. It is a program that is set up to give people firearm training and allow them to apply for a FOID card before the program is over. So Burke has sort of a mixed record when it comes to diversion for gun possession. You know, on the one hand, taking those gun possession cases out of one of their only diversion options for a bit and then putting them back in, but also helping to establish this new diversion program. So a bit of a mixed record, but only time will tell what it looks like in the future. Next, I will be talking about how Burke reduced accountability of law enforcement within the Cook County State's Attorney's Office. And to do that, first, I have to explain what felony review is. So felony review is somewhat unique to Cook County, but Cook County is also very unique because we have some of the most wrongful convictions in the country, and we have an incredible amount of police misconduct that makes a check like this necessary. But felony review is basically the process where before a case is initiated, before a felony case is initiated, assistant state's attorneys in the state's attorney's office review the charge recommendations given to them by the Chicago Police Department or by another police department, and they decide whether to initiate a case with those charges. So they review the charges and they might decide to approve them, to adjust them, or to reject them. There are cases where the state's attorney's office will basically refuse to charge somebody with a felony, even though the police recommended that the case should be a felony case, and they either dismiss the case or proceed with it as a misdemeanor. Now that I've explained what felony review is, I think you can understand why it might be important. The police often are not equipped to determine whether their arrests were justified, whether they were constitutional, whether their searches were constitutional. And they also, I think there's a clear conflict of interest with the police, reviewing their own cases to decide whether the arrests were justified. So this was an important step where the state's attorney's office had an opportunity to stop and say, maybe we shouldn't charge this as a felony. With that being said, Eileen O'Neill Burke instituted a pilot program called Expedited Felony Review, which is a misnomer because the program actually completely bypasses felony review for low-level gun possession cases. And honestly, for the three most common gun possession charges. You can see at the flow chart at the bottom that this means that instead of having to be reviewed by the state's attorney's office, the charges presented by the Chicago Police Department instead go immediately to initiating a felony case, which, for example, could lead somebody to be detained pre-trial for an arrest that may not have even been justified. And she expanded this program citywide in November of last year after piloting it in 2 predominantly Black police districts, which got a lot of flack from the community. And this policy presents due process concerns and is now present across the entire city of Chicago. It predominantly impacts Black and Latino people, largely because of racist policing practices in Chicago. And specifically, Black and Latino people made up all but 5 of the more than 200 people who had their cases initiated through this policy in the first 15 months of it being a program. It is mostly aggravated unlawful possession of a weapon offenses. And we can see that these offenses can be pretty high-class offenses. These can result in multiple years of incarceration and are deserving of real legitimate consideration before a case is initiated. And importantly, a lot of cases that result in exonerations are because of police misconduct. Between 2010 and 2025, 10 people were exonerated for weapon possession or sale, and all 10 cases involved police misconduct of some kind. And as a result of these wrongful convictions, they spent 20 plus years imprisoned collectively. And this just shows the harm that can come from not putting enough checks on the police and not doing your due diligence to make sure that arrests that are happening are justified before their cases are initiated. Next, I want to talk about Brady-Giglio lists. So basically, there is a case, Brady versus Maryland, that clarified that the state's attorney's office has a responsibility to disclose what is called exculpatory evidence. They have a responsibility to do this. Exculpatory evidence is basically evidence that is favorable to the defense. So it's evidence that the defense could use to justify their case. But in the case that we're going to talk about now, and probably the most common case of exculpatory evidence, is evidence that a witness that the state is calling may be unreliable or untrustworthy. Some common examples are if there is evidence that a police officer has lied on the stand in the past. Brady would require that the prosecution disclose that evidence to the defense so that they can use it in their arguments to potentially discredit that police officer. And this is incredibly important because with so much police misconduct, especially in Chicago, it's incredibly important that the defense has a right to know when an officer who is testifying against them has a background of lying on the stand. And we can see direct consequences of state's attorney's offices not giving the exculpatory evidence that they're required to give. Between 2010 and 2025, 89% of the exonerated cases in Cook County involved the Cook County State's Attorney's Office withholding exculpatory evidence. So this is incredibly important, and Withholding this kind of information can have severe consequences for people, including wrongful convictions. So, getting back to the policies, under Kim Fox, the state's attorney's office maintained two lists. An internal disclosure list that was basically the requirement under Brady. It documented officers who had lied on the stand, had a history of complaints, or had been arrested. And it was basically their go-to list for what officers they will disclose credibility, findings, or evidence to the defense if they are trying to call them as a witness. So whenever anyone on the disclosure list was being called as a witness by the state's attorney's office, they would disclose the evidence of lack of credibility to the defense. The do not call list was an additional thing that Kim Fox did that isn't necessarily required under Brady, that documented more than 300 officers that the office would never call as a witness. So it served as basically an additional check to say these officers have severe misconduct, and the misconduct is so severe that we will never call them as a witness. Clearly, having an additional list like that can help improve the fairness of cases. Obviously, we know that they were not catching everybody, but we do know that having policies like this does reduce the number of wrongful convictions. But what Burke did is change the office's policy so that their Brady-Giglio lists, basically they took away both the lists that the office previously had, and they replaced them with an internal, less comprehensive list of officers. And the policy also reduces the avenues that the office will use to identify evidence that might discredit a witness. So the office is generally using less, or at least the office is required now under their policy. They are no longer required to use as many avenues to identify evidence that they should share with the defense. And this is another one where only time will tell, as people are convicted wrongfully, what kind of consequences not disclosing this information to the defense could have. Next, I want to talk about prosecuting federal agents. So Operation Midway Blitz began in September 2025, and ICE agents have been committing on-duty crimes since then across Cook County. And in the first week of Operation Midway Blitz, ICE agent fatally shot a Chicago resident during a traffic stop. Obviously, people have called on the state's attorney's office to prosecute federal agents for committing on-duty crimes. And the state's attorney's office failed to announce a plan to prosecute any of them until they were pressured by both the public and by the mayor, Brandon Johnson. So the state's attorney's office finally announced a policy in February 2026, multiple months after Operation Midway Blitz had been going. They finally announced a policy to prosecute ICE agents. But as of now, to our knowledge, Burke has only charged one ICE agent with, for committing on-duty crimes. And the Burke administration actually chose to reduce that case to misdemeanor battery and to not charge it as a felony. But only one case so far, out of all of the well-documented and recorded misconduct and acts of force committed by federal agents. Also, the state's attorney's office is only triggered to go if a law enforcement agency conducts an investigation and brings charges to the state's attorney's office. So it's reliant on the police departments to initiate an investigation. Now, People versus Ringland has come up a lot. That's a court case that has come up a lot with this case and with the state's attorney's failure to prosecute federal agents. Basically, People versus Ringland allows a prosecutor to investigate a crime. So usually, they rely on the police departments to investigate crimes, bring them charges, and then they prosecute. But it does allow a prosecutor to investigate a crime if law enforcement does not adequately handle the case. When we published this report, it was to our belief that that applied in this case, and that because there are well-documented crimes by federal agents and because the state's attorney's office has up until recently, failed to act and prosecute any of them. Because the police department is what I meant to say, failed to investigate any cases and bring them forth to the state's attorney's office, that was a failure to adequately handle these cases. However, there was a petition to appoint a special prosecutor that was brought forth by the law firm Lovey and Lovey. That would be basically was calling on the court to bring in a special prosecutor to investigate and prosecute these cases because Eileen O'Neill Burke has failed to. But the Judge Reddick actually denied the petition, having a different interpretation of People versus Ringland than the one I just said, and the one that was included in the original petition to the court. However, the petition was denied with prejudice, which means that the case could still be reopened at a later date if there is more evidence or a different argument, for example. And we know that community advocates have been calling on both police departments and the state's attorney's office to adequately handle these cases and ensure that ICE agents are being properly investigated and prosecuted for committing on-duty crimes and acts of violence against Cook County residents. The last piece about reducing accountability of the law enforcement that I want to discuss is about wrongful convictions. So there are two things I want to talk about here. First is the Conviction Integrity Unit, which is a unit under the Cook County State's Attorney's Office that was started around 2 decades ago at this point, that was created as an alternative pathway for people to get their wrongful convictions exonerated. So for people to get exonerated for their wrongful convictions. There are also other avenues for people to do this through the post-conviction process or the appellate process, but the Conviction Integrity Unit was special because it was a non-adversarial process, which for some people is the best option. What the Burke administration did is narrow the scope of this unit so that it doesn't accept any cases that are currently pending in the post-conviction petition process. So basically narrowing the types of cases that it will take, which is harmful because it's important for people who have been wrongfully convicted to have as many avenues as possible to rectify their wrongful convictions. The second thing I want to discuss is certificates of innocence, which are basically really useful for people who have been exonerated because it allows them to get their records expunged and it allows them to get compensated for the time that they spent incarcerated. So if they spent years imprisoned for a wrongful conviction, they could get compensated for that time using a certificate of innocence. The Burke administration has been objecting to certificates of innocence by default and has been saying that certificates of innocence should only be granted when there is, quote, concrete, irrefutable evidence, such as DNA evidence, for example. However, this is a much higher burden of proof than the statute requires. The statute only requires that the convicted person be more likely innocent than not. So this is a much higher standard of proof than is actually needed for these cases. And in most cases, the certificate of innocence is granted anyway, eventually. The main issue with the state's attorney's office objecting to them at a much higher rate than Kim Foxx did is that it basically mostly prolongs this process for people who have already likely spent years trying to fight their wrongful conviction. They have already spent years, possibly decades, trying to fight their wrongful conviction, and this only makes it so that they have to spend even more time doing so. And that is incredibly harmful for people and doesn't actually serve the public at all. Finally, I want to talk about Burke's policies when it comes to court transparency. So Kim Foxx improved court transparency a lot, actually, during her administration by publishing unaggregated data sets on the felony dashboard. By unaggregated, I mean that each row of the data was actually an individual case, or for some of the data sets, even an individual charge within a case, which is incredibly useful for researchers like Chicago Appleseed to be able to take the data and to ask questions about what does court intake look like? What does charging look like? Who is being detained pre-trial? What are the outcomes of cases? How are people being sentenced? And how is the court utilizing diversion programming? All of these questions are incredibly harder to answer, and in some cases, even impossible to answer now. Because Burke stopped updating these data sets and has failed to meaningfully replace them in the time since. The CCSAO does have multiple data sets that they've put up, but they are aggregated, which means that researchers can't ask their own questions of the data. And the best data set that they've put up is the detention dashboard, which is unaggregated, which is a good start. But that dashboard is actually not downloadable in any way. So there is actually no way for a researcher to download it from their website and actually go through it and analyze it, which makes it pretty useless. Finally, our report presents recommendations to both the state's attorney's office and to the legislators. We have a lot of recommendations for the state's attorney's office, but the three most important ones are to reinstate the higher charging threshold for felony retail theft, to end blanket detention policies, including those for gun possession and domestic violence, and to reinstate the Brady lists and both the disclosure and do not call list. For the Illinois General Assembly, which is Illinois' set of legislators, we recommend that they do multiple things, but the main thing is to increase the felony threshold for retail theft at the state level, because Illinois does have one of the lowest retail theft felony thresholds, and to increase it to a higher amount so that local state's attorney's offices, basically have to have a higher charge threshold. They can't decide to lower it back, like Burke did from Fox's. I would highly recommend reading the full report, which is available at chicagoappleseed.org/Burke-500. There is a lot more nuance, a lot more detail that I'm not able to cover here. And you can read our full recommendations. But that is our presentation. And without further ado, I would love to pass it off to Akeisha Lee.
Thank you, Austin. That was a great presentation, so thorough. Okay, everyone, well, people hear me properly. Hopefully hear me all right. So my name is Akeisha, and I am a staff member of Mamas. So I want to start off by saying that the conditions State's Attorney Burke has created, the chill protests and resistance efforts, were predictable. So organizers within the liberation movement for like Black Lives, other issues, were proactive in their efforts to connect with Burke. We've been expressing concerns about how she might respond to like mass arrests of protesters following events like the Midway Blitz when she first came into office. So one of Burke's early public appearances post-election was a closed door forum of type at like the City Club. And first, the event was difficult to get into because it was ticketed, so not many folks were able to come. But naturally, a small protest formed outside of the event, focused on concerns that Burke would likely prioritize incarcerations over other forms of diversion and walk back Kim Fox's initiatives to decrease the number of people who are wrapped up in the criminal legal system. And to put it plainly, Burke did not take seriously the concerns of community and was purposely opaque about her policies regarding this matter. So fast forwarding a bit to just before Midway Blitz, about 5 or so weeks before, I was a frequent participant in protests outside of the Eileen Center in Broadview, Illinois. So for context, the detention center in Broadview has been there for a couple of decades, but it was thrust into the spotlight in late summer of 2025 because the conditions had worsened for the folks who were locked up inside. So the facility is like authorized to keep people incarcerated for up to 12 hours as opposed to be kind of a stop in between the next stop in their deportation process. But folks were being kept inside the facility for days, right? And again, they only had the capacity to hold folks for about 12 hours. So people didn't have proper places to sleep, didn't have proper access to medical care. Attorneys didn't have proper access to their clients. We were hearing stories of like heat exhaustion, lack of hygiene, lack of separation between people, different ages, medical conditions, and gender identities. So hearing about these conditions inside made me and others feel like we had to act. And ultimately, I was arrested outside the facility. So for weeks leading up to my arrest, interactions between protesters and ICE agents escalated week to week. And I don't want to make a distinction truly between like good and bad protesters, but I do think it's important to say that the protests at Broadview at this time in particular were largely led by members of the faith community. And they were folks who explicitly had stances that were rooted in the nonviolent like practice and tactic. I recall, for instance, one protest that was like formatted like a block party. We're giving out free food, doing mutual aid, talking about how to organize like ICE observation, things like that. And in response to this block party, we were shot with tear gas and other irritants. We were threatened with tasers and live ammunition guns. We were shot at like near us with rubber bullets. And this is all in response to a block party. And there were families there, open mics, and free food. That's how ICE was treating people at the time. So after weeks of being violently treated by ICE, Governor Pritzker deployed the Illinois State Police to control the crowd at Broadview. And according to ISP leadership, they were presented with the opportunity to keep us safe from ICE, to make sure that no one was killed or seriously hurt by ICE agents. And I'm sure that you all can kind of see where this was going. Like ISP arrived and they quickly aligned themselves with ICE, right? They were standing in opposition to our protests. They used violence to stop our march. So between the time that ISP and Unified Command joined ICE at Broadview, there were about 90 people, including myself, that were arrested by ISP and the Uniform Command over the course of those weeks. And during the same time that these protests are escalating and detainments and kidnaps are also escalating, the community is calling for the dropping of these charges. They're asking and demanding and urging Burke to drop our charges because it was clear that what ICE was doing in community was far more concerning than protests, and that the state's concern should be focused on containing ICE, not on us who dare to express objection. So we were made to appear in court monthly to fight state charges, making clear that this is all up to the discretion of Burke. So we're being made to go monthly to these charges. Every time we appeared in court, the state was not prepared to move the case forward and ask for continuances. And our lawyers would say once again, like, how is the state justifying using the time and energy on this matter? So following the murders of Renee Good and Alex Preddy, community members renewed their calls to drop these charges against myself and other protesters, seeing once again that the terror was being caused by ICE and that protesters were doing a duty to their community by speaking up. So eventually my charges were dropped, right? But not before spending months in court and not before other protesters felt compelled to take plea deals. Many of the folks who took plea deals just didn't have the resources needed to continue to fight the charges, right? Every time we went to court, we had to take off work and rearrange our lives to navigate these charges that weren't rooted in anything about public safety. And even when the charges were dropped, the state made it a point to say that they weren't doing so to be aligned with resistance, right? They claimed that they just decided to drop it, right? Like really showing back the lack of reasoning, really showing that the state's attorney's office is determined to present themselves as being unswayed by community interests. So thank you for your attention. And with that, I'm going to pass it over to April to share another personal experience about how she's been impacted by State's Attorney Burke.
Well, good evening, everyone. My name is April Ward. I'm a member of Mama's Mother of the Kidnapped Collective. My son is Mikael Ward. He is serving an 84-year sentence for a crime he did not commit. I have been fighting to prove his innocence innocence for 14 years. For 14 years, I have experienced how the state attorney's office is a barrier for my son and others because they believe people are guilty until proven innocent. The injustice didn't start with Elaine Burke, but she is certainly using the groundwork laid by previous state attorneys to advance racist and classist policies to lock up Black and brown and poor and working class people. During his trial, my son was painted as the face of gun violence in Chicago, not just locally. His name, face, and case was also used by the Obamas to push their gun bill through. He was a scapegoat goaded by the local politicians, prosecutors who used his case to advance their own careers and agendas. Many of the people involved got promotions off his case. Now, with Burke in office, we can see the continuation of racist profiling and enforcement of gun regulations in the way that Burke has implemented the felony review bypass, which was first used in Black neighborhoods like Inglewood to lock up more Black and brown people. This is unfair and unjust, and is resulting in more of our kids and community members being held in jail while the state's attorney builds their case against them. We know that people being locked up while waiting for trial disrupts their lives. People lose his job, housing, even their kids. Similar to my experience now with Mikael being back on retrial. It keeps you in limbo, unable to really move forward while waiting for the states to get their act together and get on with the trial. Where where is the rights to a speedy trial in this when it takes years? So I so as I said, Mikael was back in court. He appealed his conviction and won. The Illinois Appellate Court ordered him to have a new trial back in 2019, but the state was upset that the court ruled against them and appealed again, taking it all the way to the Supreme Court. Eventually, the Supreme Court also ruled in Mikael's favor, and his case has been returned to the circuit court for a retrial. Here we see the state attorneys fighting, a state's attorney's office fighting even before the trial can really start, fighting to make sure the trial that he can't be released on pretrial, just like the first time. They are painting him as a dangerous monster, saying that he's a threat to the community, and again, making it impossible for him to have a fair trial. Elaine Burke has made it a standard for her office to fight all post convictions appeals, which Mama Rosemary is going to speak to more in a moment, which unnecessarily wastes taxpayer money on court proceedings. It's confusing for loved ones to have to keep going back to court doing the same things over and over again. It's one continuous after another. The state's attorney's not ready. Somebody didn't get an email. The judge didn't have time to read something. It keeps us all in waiting, going in circles. They keep sending us around, and it's a load of bull. In addition to the state's team of attorneys, the Chicago police has a team of attorneys fighting against Mikael, in part due to his case involving a known torture cop, John Holleran, and also because the prosecution relied on the gang database in building their case. We know that the gang database was incredibly racist and was used to falsely label many of our Black and brown kids as gang members. All of our kids are not in gangs, and destroy our communities by locking up our family members. Knowing this, the gang database is no longer used. Similarly, there was the Brady list, as Austin spoke about in their presentation. This was a list created of no-call cops and people. Previous state attorney knew not to call the people on this list as they are uncredible, corrupt, and have conflicts of interest in testifying on cases. Elaine Burke, however, has eliminated this no-call list and a lot of the transparency that existed before her. This causes even more issues for folks trying to fight their cases and is totally ridiculous. How are we going to say it's okay to call cops to testify who other judges have discredited? All this part of why we, as families and community members who have lived through all these trials, have to keep coming together. We know things, we've seen things, we've experienced things over decades, being in and out of court. We know that there are patterns of corruption and abuse, and that all these cases are connected. And instead of the state's attorney using these positions to right past wrong, she is hiring more prosecutors to spend more taxpayers' money to keep fighting these cases we know are bogus. And with that, I turn it over to my friend Rosemary.
Hello, everyone. My name is Rosemary Cade, and I'm with the mothers of the kidnapped. My son, Antonio Porter, was released in January of this year after doing 23 years and 9 months for a crime he didn't commit. Antonio was back in court fighting his post-conviction for nearly 3 years. He filed his petition to come back in court in July of 2023. The state dragged out their response for a year and a half. We went to court 12 times just for to get be continued every time. And then the state's attorney filed against him in November of 2024. Then Burke came into office and changed around staff, which meant more delays because the state had new attorneys on the case. Evenly in January of this year, 2026, the judge ruled to vacate his conviction. I share this to show how ridiculous of the timeline is on these post-convictions appeals. I was going to court. It put a lot of stress on me. I was going through difficult times trying to get to court, issues with my car. And also I was dealing with kidney problems, my heart, also breast cancer, and also was on dialysis. It was a lot to deal with. Then to deal with my son having been locked up for something he didn't do. That took a big toll on me. And other mothers and family members were also making time to get to court to support us. His judge ruled that Antonio should get a new trial, but the state's attorney office decided to recharge Antonio and fight the judge's decision and send it to the appellate court. Now we have to wait, probably a year or two for the appellate court to make their decision, to either go ahead and have a new trial or reverse the judge's ruling, which would mean Antonio would go back to prison and have to start the post-conviction process all over again. This isn't the first time Antonio had to go to the appellate court in his struggle to prove his innocence and get free. It is ridiculous that we are back here again, though the facts that Eileen Burke has made a policy to fight all post-convictions appears is ridiculous. A lot of time, the state's attorney office, even looking at these cases, they don't even look at these cases. They throw them to the side, not reading or trying to organize to try to get expand. When Kim Foxx was in office, it was under-resourced from the start. The fact that Eileen Burke has now cut back the resources just goes to show that she isn't really interested in justice for anyone who has possibly wrong convictions. She would rather fight everyone in court, which means that the taxpayers are spending more to pay the judges, the prosecutors, the court staff, as well as it's clogging up and slowing down everyone's cases because there are only so many courtrooms and so many judges. She's causing more backlog than already was and keeping people in prison while they are waiting, and then saying that they're short-staffed and can't handle the caseload, which is ridiculous to me. Which she is then hiring additional prosecutors at ridiculous hourly rates, which again, we as taxpayers is paying for it. Then when people to get their retrials and are found not guilty of these cases and are vacated, she wants to cut out the certificate of innocence. People should be compensated for the time they spent in prison wrongly convicted. All they miss in life, they need to be compensated for a lot of things that they sit in prison waiting and waiting and waiting. The wrongdoing of the state, the city, the police department is unfair to us and our families. It's unfair to the people in prison. It's very unfair to all of us. And we shouldn't have to suffer for all that time they have to spend in prison, especially when they are wrongly convicted. And how these are no state resources to help them. People need the certificate of innocence, not only for the money, but also to clear their records so they can get jobs, housing, all the stuff you need to survive and succeed out here. It's hard to get their lives back that they lost. No amount of money is ever going to make up for that. But it helps. The state wants to claim there are no resources available because there are no funds. And they want to not pay out these certificate of innocence because there's no money. And yet they want to increase budgets for the polices, for the prisons, and for the state's attorney's office. Make it make sense. So all of this is why it's so important for us to have these community conversations to talk about the issues and our experiences, to get educated and know what's going on so we can get organized and fight back together. Thank you.
Thank you so much, Rosemary, and thank you
You're
to April and
welcome.
Akeisha as well. Yeah, thank you. Yes, okay. We're now going to open it to questions. If anyone would like to submit a question at this time, and we can answer them. Okay. Well, if we have no questions at this time, then you can always reach out to us at Chicago Appleseed via our website, and the Mama's website as well are both linked in the description. And I think now we are going to have some of our members share out some calls to action that are relevant to tonight's conversation.
Yeah, thanks so much, Allison. First of all, amazing job by all of our speakers. You all did an amazing job. And it's really impactful to hear more direct stories, because you can talk about policies all day, but what really matters is the human impact that the state's attorney's office is having on real residents of Cook County. So thank you for that. And the only call to action on Chicago Appleseed's end is to read the full report, as I said earlier. But I'm excited to pass it off to Akeisha to give some more direct calls to action that you can all take. So I'll pass it off to you.
Thank you so much. Hi, everyone. Thanks for hanging in with us on this Wednesday? Yeah, this Wednesday. Okay, so mamas, we have frequent calls to action that you can find on our page and on our Instagram. We're on Instagram at Mothering is Radical. You can find the calls to support our member sons as they continue to navigate the criminal legal process. We are constantly asking for court support because court support makes a big difference. We have to show the state that the folks that they are keeping languishing in prisons and navigating court system are missed by their community. So you can see our regular calls to action there. We are launching a book about the experiences of our members and mothers of the kidnapped. Our book launch event is next month, and we're going to have an event to talk about the book and show where you can support us there. Again, you can find that on our Instagram page. It is next month. It will be in person. And then finally, there is a call to action for court support for one of our community members. 1 second, bear with me while I pull up the flyer. Okay. I actually can't find the flyer in front of me right now. If anybody has the flyer, please come off mute and talk about it right now. Otherwise, it will be in our follow-up notes.
Yes, thank you, Akeisha. And with that being done, we're done pretty early today. Sometimes you can say a lot quicker than you think you can. So thank you all for being here. And